Greetings, everyone. I am Dean Andre Cummings, and I am delighted to welcome you to our Jurist in Residence lecture this beautiful day in our fabulous Wolfburg courtroom. And this event is sponsored by our Law and Government Institute. I have often said this in the 20 or so months that I've been dean. The Law and Government Institute is one of the foundational pillars of our law school. In fact, I was just in this room 2 days ago talking to a whole bunch of prospective law students, the largest group we've ever had. And I said these words: we basically run the state of Pennsylvania because our Law and Government Institute has put our lawyers in every conceivable important agency, at the head of the state, at least in the Attorney General's office, and as I always like to say, the right and left hand of the governor. But every important agency in this state has our lawyers leading them and our lawyers doing the good work of the law and government in the state of Pennsylvania, which I also reminded the prospective students is the fourth most populous state in the Union and one of the most important states in the most important country in the world. So welcome. I love the Law and Government Institute, and I'm so glad that it is sponsoring this event today. And I just wanted to point out Brent Finkbeiner and Grant. Help me with your last name, Grant. Villa. I could say the whole name. Grant Villa Rodriguez as our Patrick Murphy Fellows that help us run our Law and Government Institute. And I also have to shout out Rob Teplitz, who is the director of our Law and Government Institute. He runs it expertly and keeps me on task. Jill Family is our faculty advisor, and so I'm really delighted to welcome you all here today. The Law and Government Institute has three objectives. The first is to help students earn specialized certificates at graduation in either administrative or constitutional law, in environmental law, in government contracting, or in legislation and public policy. That's the first of our three objectives. The second is to host public programs like today, like this one that explore and debate important topics of government law. And third, to contribute to the development of government law through scholarly and employment opportunities, which we do a fabulous job at. I also told the prospective students that if they were interested in state government law or in law and government, there's probably not a better law school they could go to in the nation. I said those words, and I stand behind them. A few housekeeping issues before we begin. We are recording this program, so your continued participation is your consent to being recorded. Okay, so you've all been notified. Secondly, this program is eligible for CLE credit. If you're a lawyer and want CLE credit, then hard copies of the forms are available out at the check-in desk. There will be time for questions at the end of the program, and we will be monitoring the chat for questions from online participants. And I am really delighted that our jurist in residence, Karoline Mehalchick, has been with us leading our efforts as our jurist in residence this year. Judge Susan Schwab was our jurist in residence just a couple of years ago. And we're really delighted to have all of our speakers here today. So at this point, I'd like to bring up Brent Finkbeiner. He is our third-year student, serving as a Patrick Murphy Fellow and a Government Fellow through the Institute to introduce our program today. So welcome, Brent. The floor is yours.
Thank you, Dean Cummings, and thank you all for being here tonight. It is my honor to introduce Widener Law Commonwealth's Jurist in Residence, Judge Karoline Mehalchick of the United States District Court for the Middle District of Pennsylvania. Judge Mehalchick will be moderating the panel and introducing the other speakers. Prior to her confirmation as district judge in January of 2024, Judge Mehalchick served for a decade as a U.S. magistrate judge, including 3 years as chief magistrate judge. She is a graduate of Penn State's Schreyer Honors College and Tulane University School of Law. Before joining the federal bench, she worked as a judicial clerk, a partner in a law firm, and an adjunct professor. Throughout her legal career, Judge Mehalchick has been recognized for her contributions to the bar and community. She is a recipient of the Pennsylvania Bar Association's Michael K. Smith Excellence in Service Award, as well as the Lackawanna Bar Association's Margaret P. Gavin Award, which is presented to an outstanding young lawyer member who is dedicated to service to the bar and community. Judge Mehalchick was recognized in 2012 by the Legal Intelligencer as one of 35 Pennsylvania lawyers on the fast track, and in May of 2020 by the PBA's Commission on Women in the Profession as a woman trailblazer. Please give a warm welcome to our jurist in residence, Judge Karoline Mehalchick.
Thank you very much for that introduction. I'm very happy to be here today to talk to you guys about the rule of law and threats to the independent judiciary and the role that all of you might play in those issues. I want to take a moment and introduce my panelists here that are here with me today, starting with Judge Susan Schwab on my left. Judge Schwab is a magistrate judge with our court in the Middle District of Pennsylvania and a former jurist in residence of your school. She's also your school's first valedictorian. So she is a honored guest here today. Judge Schwab has been on the bench since November of 2012 after over a decade of public service and a career in private law practice. Like I said, she has the distinction of being a member of the inaugural class of Widener Commonwealth Law School here, and the school's very first valedictorian. She is my friend on the bench and my colleague, and the longest serving now magistrate judge on our bench that currently sits there. So we appreciate your no. Not meant to sound old, just meant to sound very experienced. And we look to you for all sorts of guidance all the time in all of our roles. So thank you for being here with us. You're welcome. And then to my right is Sarah Hyser-Staub. Sarah is a litigation attorney and chair of the White Collar Defense Public Corruption and Investigations Group at McNees Law here in Harrisburg. She is a graduate of the Penn State Law School, and she is a former law clerk to the late Judge William Caldwell of our court. She graduated summa cum laude, like I said, from Penn State Law in 2013. And she brings a interesting and diverse perspective as a practitioner to this panel today, representing witnesses and targets before state and federal grand juries, defending individuals and businesses in criminal and regulatory matters, defending public officials, and assisting clients with disputes before a number of entities, including the Department of Justice, the Office of Attorney General, Pennsylvania Department of Banking and Securities, and many other state and federal agencies. Sarah, thank you for joining us. Here. I know Dean Cummings mentioned calling for questions at the end of the session, but we have discussed this, and we really would encourage you to ask questions throughout today's program. So, and those of you online as well, if you submit your questions in the chat, I've been promised that I'll be flagged down, and we can have those questions read out loud and answer them as well, because I really think this is important that we have a conversation about these issues, and encourage you to ask as many questions as you can as we go down through this topic. So for those of you who were around last year when we had our Jurist in Residence lecture, you may say, isn't this the same thing we talked about? Because we talked about the rule of law last year as well. And that is true, we did. But it continues to be a very important topic for me and for my colleagues, and really should be an important topic for anyone who's involved in the legal system in any way. Last year, we focused on this concept very generally as to what the rule of law is, what is judicial independence. And this year, the goal is to really drill down more into the immediate and practical effect of these issues on courts and our profession in general. For those of you who are law students in the audience, I think it's important to think about what this means for you as you are coming into this career. And for those of you who have more experience, it's important for you to reflect on what your role is as a lawyer and in this profession. The public's faith and confidence in the judiciary has been decreasing at an alarming rate in the recent years, and there's been an alarming increase in verbal and physical attacks on state and federal judges throughout the nation. Judges have been routinely subjected to hostile, inaccurate, and intimidating verbal attacks about rulings they make, and physical and verbal attacks imperil the independence of the judiciary. Continued attacks threaten our independent judiciary. They threaten the rule of law for everyone. Justice Roberts had ended his 2024 year-end report, had issued his year-end report calling out 4 major issues threatening an independent judiciary. That being misinformation and disinformation, threats, and violence against the judiciary. And he recently came out and was very outspoken about the need for these threats to stop against judges. There has been an alarming increase in these threats over the last couple years, but let me be clear that this is not something that's completely new. Threats to the rule of law, threats to judges, violence against judges is something that has occurred in past years. This is not a partisan issue. And although we'll talk about more recent things that have happened, these are issues that have happened. These calls for actions against judges, threats against judges happen across party lines. And they happen without mattering. It doesn't matter whether you are a judge that was appointed by a Democratic president or a Republican president. They are threats that happen to everybody. And they've happened for years. Disgruntled litigants for years have decided that they can upon themselves to take physical or verbal action against judges when they're unhappy with rulings. The problem now is that with the spread of social media, with the rise in negative rhetoric, that these are occurring more and more often. But by way of background, our Constitution and our government and our democracy is based on the idea of a fair and impartial judiciary that follows the law and is not biased, it's not partisan, it's not easily intimidated. Judicial independence was determined to be critical to fairness and impartiality by our framers. Hamilton, in the Federalist Papers, says there is no liberty if the power of judging be not separated from the legislative and executive powers. And he says that when he's discussing the need for the judiciary to be appointed for a lifetime and without term limits. And he also talks about how the judiciary is the weakest branch of government because we don't have the power of the purse, we don't have the power of an army. We are dependent upon the other branches of government to enforce our orders and to follow our orders that when we interpret the law. So I want to talk about the rule of law. And before we talk about what the rule of law is, I'm going to ask you, who wants to tell me what you think the rule of law is when we talk about this concept, this amorphous concept? Anyone want to volunteer? I know my students are all here and we've talked about it. So go ahead.
So the rule of law is the idea that the law applies equally to everyone.
Okay, so it's the idea that the rule of law the law applies equally to everyone. That's great. Does anyone want to add to that at all?
Judge, I see the law as it's our social contract. It's what we agree to do or not to do to and with each other.
Right. So a social contract, what we agree to do with each other, and again, you said to each other, with each other. That's social contract. One more. Anyone else?
On Judge Wilson.
Judge Wilson, what do you think? Welcome, Judge Wilson.
Oh, yes.
So glad you could join us today, aren't you?
The rule of law is generally applicable and known and knowable to everyone, so it can be applied equally, as was mentioned.
Right. So it's transparent. Everyone knows what it is. It's a contract that we have with each other to make our government work. Judge Schwab, what do you think the rule of law is?
Oh, now you're going to call on me, right?
Turn around is fair play.
When I think about the rule of law, I don't think about one thing as a judge. I think that it's obviously it's equal justice under the law, and we are a nation of laws, not men, right? We are not king-made laws. We are man-made laws. But as a judge, I think it's very multifaceted. It's not only case law and statutory law, but it's procedural rules, the principles of precedent and stare decisis. And then I also think that you can't have the rule of law without conduits, and not empty conduits, to administer that law. And that's, I think, where judges come in as the facilitators and interpreters of the rule of law. And what do you get with judges? Well, you get experience, judicial decision-making, and that's very individualized. Judges decide things in different ways. And I think you get and Judge Mehalchick and I were talking about this earlier, and with Ms. Hyser, you get humanity. So the rule of law is not static. I think it's filtered through judicial decision-making and through a human person. And we're going to talk, I hope, in a little bit about AI and the emergence of that and how it's affecting the rule of law. So I don't think of it as one thing as it applies to me in my day-to-day work.
Thank you. Is there anything to add as to what you think the rule of law is?
And follow that.
Yeah.
I would say certainly agree with what has been said so far in the room, but to me, one of the most important factors of the rule of law is that it's an independent and unbiased application of the law. It's just
Right. So it's this idea that you have these laws, everything that comes into making the laws and interpreting the laws. But it's this principle that all the people, all the persons, institutions, the entities, everyone's governed and held accountable to laws that are just, that are public, that are equally enforced and independently adjudicated. And it's that last part that is really important to us as we talk today, because we've all taken, judges, when I say we, I'm not talking about the royal we, I'm talking we as judges collectively have taken this oath to uphold the laws of the United States, uphold the Constitution, and to rule without fear or favor. And it's this idea of what happens if that gets threatened, if there starts to be something that we consider outside of the facts in front of us, outside of the law that's presented to us, outside of what we're bound by, does that start to dig at and weaken this idea of the rule of law? And what does that mean for everybody here? And what does that mean for every citizen in this country? So when we're thinking about the rule of law or this concept, and I'll start with Judge Schwab, do you think about, is this every day when you sit down to a case, do you think, how do I apply? What do I do with the rule of law? How do I make sure this is being applied correctly?
I guess I don't think about it in those terms, like what am I doing with the rule of law, but everything goes into the mix. Where are we at procedurally in the case? What's going on? Who's, suing, in a civil case, let's talk about who's suing who. Where are we, how long has this case been hanging around? I mean, I don't think we have rule of law and efficient judicial management if we're letting cases languish. We do, as magistrate judges, we do a lot of pro se prisoner cases. So you can't have the rule of law without access. And always making sure that pro se plaintiffs, especially pro se prisoners, are getting the access that the other side has. Now, clearly they're in prison, so they don't have the same materials. They don't, they get pens and paper. They're not getting computers, that sort of thing. So always thinking and ferreting out, like, where are we at in space and time, and how can I be, even discovery disputes, we're fighting about producing documents. Okay, how does the rule of law come into that? Well, what is the rule of law? What's the law surrounding that? And then how, as a judicial officer, can I facilitate the outcome or justice in that regard? I mean, sometimes it's like facilitating a third grade argument, but that's.
Let me follow up
my
on
answer.
something before I ask Sarah the same question though. But how does that play into? You mentioned pro se litigants or a third grade argument. When you're issuing an opinion or writing something, do you think about how it might be received by the litigant? Do you consider your writing style such that for a particular audience? Do you write in a certain way? Thinking about that in terms of making sure people understand it?
My law clerk is here. She could tell me whether I write in a certain way. I think, Maddie,
So it's fair. It's just a. Judge Schwab was a former English teacher, so she's going to call on all of you without shame. So I don't know, Maddie, if you want to speak to that or not.
We're writing for, sometimes it's a report recommendation, so we're writing for another judge, we're writing for, future other people who are going to read the case that are
judicial, Third Circuit, anything like that. But we also have to, at the same time, think about, okay, are these lawyers or are these a pro se litigant and a lawyer, or just two pro se litigants? And sometimes that means saying a pro se litigant, footnote, i.e. someone who isn't represented like you, we don't say you, but the plaintiff's name, we're trying to explain those things. We're trying not to just use Latin or whatever that I think makes law more or less accessible. We do try to do that, but at the same time, you're writing for so many different audiences at once. The Schwab has taught me a lot about that balance.
Well, I'm very aware of the story we're telling, because that's and that we're telling it in plain language, because I do think that written decisions are a way for not only the litigants, but the public that's reading them, and maybe even the media that's picking up on these cases. Not that I'm doing media-worthy cases, Judge Mehalchick and Judge Wilson are, but I think this is where perception of the judiciary, we can do our part in the way we write to make it clear what we're saying, so we're not getting this constant backlash like we seem to be getting now about our judicial opinions, because we're in a world of sound bites here.
Yeah, no, I agree. I think that, my instruction to my law clerks, what I tell students, what I try to practice all the time is writing in a way that is plain and understood by anyone on the street. Whether it's a case that's being written with two corporate clients or two corporate parties, or very highly educated and experienced lawyers and their clients, I want the person on the street with a high school education to understand what it is I'm saying. And sometimes it's hard to do. We deal with some complicated concepts, but the idea is to try to explain it in a way that the general public can understand, to make this accessible, to make that rule of law, to make this concept accessible to everybody, and to make sure that they understand it in a way that's important. We've had some colleagues who insist on using Latin all the time. I can't think of the last time I used a Latin phrase in an opinion, because most people don't know Latin anymore.
I like to say seriatim,
Yeah, I like to say arguendo, but but other than that, I don't know. But generally it's very, it's the idea that you're writing. When I think about the rule of law, sort of as a general idea when I'm working, it's the idea that I want my decisions to be transparent and understood by everybody, so that they understand that it applies to everybody. Let me ask you, Sarah, why is it, as you represent clients, why do you think fair and impartial courts and fair and independent judges are important? What is important about this for you?
Well, so as a litigator, I counsel clients every day on how to guide their behavior, how to run their businesses, and how to comply with the law. And so part of that counseling involves assuring them that the law is stable. The law, stare decisis, here's what an opinion says. Here's what you should do based on that opinion. There's new legislation. We provide guidance in that regard. So to me, the importance of the fair and impartial courts has to do with allowing everyday American citizens to continue pursuing, their freedom, their happiness, everything about being an American, right? You can order your life accordingly, because you can expect that there will be a consistent and fair tribunal where your grievances can be heard. And so to me, I think that's what's so important to me, is to the rest of us can go about living our lives, because the lawyers are here working for you to make sure that, you're going to stay within the lines and that those lines won't be crossed.
And again, I want to remind you to please ask questions if you have questions as we go along. But when we talk about judicial independence and judicial impartiality, we're really talking about two different aspects of it. We're talking about decisional independence from outside pressures on each case, and independence generally of the judicial branch. These days, those two things kind of conflate in a lot of cases. But like I said before, every single one of us has taken this oath to uphold the Constitution, to rule without fear or favor, and to follow the Constitution and laws of the United States. When they talk about and I just want to touch a little bit, I mentioned it, in the increase in threats and concerns to judges. some of the things judges are facing right now are things like pizza doxing. And if there are those of you who don't know about this, it's the idea that you're at home and the doorbell rings and someone's delivered a pizza to you. And you didn't order the pizza. And at first blush, people think, oh, this is like no big deal. I got a free pizza, right? But it's actually a message that's being sent from someone that says, we know where you live. We know, in some cases, the pizza is sent to your children. We know where your children live. We know where your family lives. And a lot of these, I'd say about half of them in the last couple months have been sent in the name of Daniel Anderl. For those of you who don't know who Daniel Anderl is, he was the son of Judge Esther Salas, who was killed in her home by a disgruntled litigant. And that happened, I want to say it was 2020 at this point. I think it was
about 5 years ago.
About 5 years ago, 6 years ago. And so then it's also being sent with the idea that we're sending you a pizza in Danny's name because you might have a case. And you may not even know what the case is. You don't know who sent it. But judges are dealing with that. Judges are dealing with things like swatting. Judge Kuhnauer, who's come out and spoken about this publicly, is a sitting judge in the Washington state, and opened up his door one evening to the doorbell to a SWAT team outside his door who said, we need to see your wife. And he said, what's going on? My wife's inside. They got a call that he had murdered his wife. So you have judges facing those kinds of threats. And this is in addition to the countless what we'll call inappropriate communications that we get that I think every judge I know has gotten at one point or another that don't actually amount to threats. But they are constant reminders that if people are unhappy with us, and let's face it, in everything we do, at least one person is unhappy, that they now feel empowered to take these extra steps against judges when they're making rulings or considering making rulings. So on that very positive note, let me ask you.
Jump in on
Sure.
that? I find in the threats that I've gotten that they're not the criminal defendants.
Oh, they almost never are, yeah.
They almost are never the criminal defendants. I mean, those guys know the drill, and they're not the problem. It's the civil litigants, and sometimes they're not making direct threats to you, although we've had that before. But sometimes the way they're bombarding your chambers with emails and in the middle of the night. I mean, I had a situation where, a litigant just kept, I mean, I would get how many a day? 50 a day we'd get. And then in the middle of the night, maybe I'd wake up to go to the bathroom. There'd be 50 more in the middle of the night. So somebody's doing that in the middle of the night, that in and of itself, even if they're not saying anything threatening to me, that is threatening. And another litigant knew, they can look us up, even though we all have programs now where there's delete me programs where the marshals are going in and they're supposed to be taking off our personal information off of the internet. They still can find out where Judge Mehalchick lives, and they can find out a lot of information about you. We're sort of public figures. I've been involved in many community organizations. They find those pictures, they find things, and then they start repeating them back to you. I mean, it's very unnerving. And everybody knows, and I live in Camp Hill. It's a very small community. There's no way you can't go there and probably find me, right? All you have to do is sit at Cornerstone Coffee for 2 weeks, and I'm going to be there, right? And so even at our level, where there are these threats, and they're just increasing.
Well, they're increasing, and what we're finding is that they are repeated on social media, and so you have rhetoric that says judges are monsters, or judges are morons, or judges are, this judge isn't doing what they are she's supposed to be doing. And that appeals to what I'll call a mentally vulnerable population who is looking for some sort of answer and some sort of way to react. And it feeds on itself. But let me ask you this, Judge Schwab. When you get those situations, have you found that impacts your ability to do your job?
No, I mean, I'm not afraid of doing my job, but it just kind of makes you a little wary, be more, less, or more careful, look around you a little bit more. We put no solicitation signs up at our house, even though we have the ADT sign up. But no, I don't think it's deterred me from doing my job. And we also have the federal marshals that we call in, and they listen to us, but they're so inundated with other threats. And I think we work together. Sometimes when I've had threats, I've given the case to another judge, and just to switch it up. And then that takes care of the problem.
And I think that you touched on a point about the no solicitation signs at your house. I think there's an issue. One of the things that I think is important to understand is, one, you mentioned the marshals. None of us have marshal detail. It's not like we're the president. We don't have Secret Service around us. Like, we don't. It's not that type of situation. But the other thing is that we've signed up for these roles, right? The judges have said, we want to be this public figure, but our families haven't. And so it impacts, your family when they're at their house. Esther Salas' son, obviously, it impacted them in the worst way possible. My daughter, who was only 4 when I became a magistrate judge, told me the other day that there's not a day that goes by that she doesn't think about, not that she's worried about it all the time, but it's just in her mind that, hope mom's okay today. Wonder if anything's going to happen today. Wonder if what might happen. And so that's not something she signed up for, but that's the reality that she lives in. Sarah, as an attorney representing, individuals and entities, what role do you think the attorney plays in this? Is it client expectation management? Have you had to deal with anyone with unreasonable expectations in this regard?
I do think there's a lot of client management work to be done in that regard, because it sort of has turned a lawyer's role into, you go from the counselor and the advocate to almost an ambassador as well, because I know, because I spent a short period of time as a law clerk, but I know certainly from my experience there that the judge's loyalty is to the law and to apply the law without passion, dispassionately, et cetera. And so I try to hearken back to that experience, and I often will use that experience and say to clients, look, I was on this side of it, and I could tell you right now that this judge does not have anything against you because of your political beliefs or because of something you did to your anything like that. It's it just do everything that I can to reinforce confidence in the judiciary and in the system and the way that things work. And I have had instances of clients wanting to advocate for something that is just plainly against what the law says, and then frustrated when that outcome isn't reached. And it's definitely a management issue. And as to the law students, it's often not something that is taught. I'm not sure it's taught in law school. Maybe it is, but I don't believe that I learned that, here's how to tell your difficult client that their idea is completely insane and that you cannot possibly win this case, or that this summary judgment is never going to be granted and they can spend tens of thousands of dollars, but it'll be wasted. So yes, it is definitely a client management issue.
Right. And part of it is, I think, client management in terms of what to expect if you lose. Right. When you lose, the answer is, and we all know this in this room, right? The answer is you take an appeal. And all of us have been appealed, and all of us have been reversed. And I think if there's a judge who hasn't been reversed, they've been working for 3 weeks. But, it's it happens to us, and we're okay with that. I mean, we don't love it. I don't know. I don't love it, but it happens. It's not a big deal. What shouldn't happen is, take to social media and start calling the judge names or make inappropriate comments or things like that. And I think managing those expectations is something that's been having to increase in recent years.
It is, and I certainly I have a strict no commenting on any litigation rule with clients. And if they are going to be doing things like that, frankly, they won't be a client for very long. So you have to be careful of the ethical rules about withdrawing from cases, but it's very clear with clients of you do not comment on pending litigation unless it's approved and things like that.
Yeah, Maddie. Absolutely, absolutely.
I'm curious, Sarah, whether you've dealt with cases with a pro se litigant on the other side, and how you manage some of that. Just, I know that Judge Schwab has had cases that I've seen where it's almost like every time she would rule against a pro se litigant, it would be like, well, all lawyers are in cahoots somehow, right? And so I'm just wondering how you handle that.
And let me just repeat it so to make sure that people online are no problem. Is the question is really, to Sarah, how do you handle a pro se litigant on the other side to sort of dispel the idea that all lawyers are in cahoots with each other or collaborating some way?
So the answer is you're not going to like it, which is there's really no good way to handle that. I have had numerous cases with pro se opposing parties, one of whom did also email me in the middle of the night constantly, Judge Schwab. I would wake up, and the judge, and to the point that the judge almost held her in criminal contempt for all of her emails, but that's another story. But different court, though. Different court. No, actually, this was in California, so different court. But I do, and in fact, I have one right now. And when you said that, it made me think of this very specific person that is an opposing party in one of the cases where I actually represent a government subdivision, a political subdivision, against an individual who very firmly believes that all lawyers are out to get everyone, and that the judges are, in cahoots, and that the Third Circuit should be, there's really. We remain respectful in our pleadings. We don't, when they go low, you go high, to quote Michelle Obama. We try very hard to just toe the line. But I have not. If you find a way to deal with them, let me know, because I have not succeeded. We kind of just keep plugging away. Now, it's extremely frustrating for the client, because the client is spending crazy amounts of money to defend these cases, and it's seemingly, frivolous and whatnot. But we're going on 4 years of litigating with this individual with no stop in sight. So it's just a problem.
Kara?
I think it sort of goes to the idea that these threats, inappropriate behavior is increasing. And I know you've discussed that a lot of that sort of comes with the messaging that we're seeing at the top of the system, and that setting an example for what's appropriate behavior for society as a whole. So I'd love to just hear, what can judges and law students, lawyers who aren't obviously at the top of the system do to sort of try to mitigate this issue?
Right. So the question is, to summarize it, is really what can judges, lawyers, law students do to mitigate the negative rhetoric that we're hearing from more people in power. And again, I'll reiterate, and I've talked about this a lot, that rhetoric comes from both sides. We've seen examples of it from all political parties. And my thought on that is that we keep doing things like this. We keep having a conversation. You take what, to the law students who are here today, you take what you heard today and you go home for whatever your next holiday is, or your family, and you say, hey, today I sat in a lecture with 2 federal judges and a federal practitioner, and this is what we talked about. Or the next time someone says, makes a bad lawyer joke, you say, that's not funny. Let me tell you why lawyers are so important to our democracy. Or the next time someone sees a ruling in a paper, or they, and the criminal things get more press often than the civil things. So if someone says, I don't understand why that judge gave a sentence like that. It's explaining that, it's not as simple as just, a number of months. And there are a whole bunch of reasons for why a sentence may look like it does. And continuing to talk about it. I think that's civil dialogue and that's civil discourse. And I'm not saying you have to agree with everyone all the time. You're never going to. But if we can have the conversation civilly, if we can have it in a way that everyone's mind is open to hearing other aspects, then I think that that's what you do. Judge Schwab, I don't know if you have anything to add to that. I can add from the judge while you think about that for a second.
No, I can.
Okay, go ahead.
I think that it also starts much earlier than law school.
Mm-hmm.
And many school districts, I don't know if it's mandatory in Pennsylvania, but many school districts now offer civics classes. And it starts.
It's not mandatory in Pennsylvania, but some school districts have recently reinstated civics education as a requirement for high school.
I know Camp Hill does because I've gone in there and talked to them. And I think, it starts in the 7th, 8th, 9th grade when they first are learning about government or whatever, and that they, listen, I spoke, Judge Carlson always used to speak to the Catholic school, the grade school down here in Harrisburg, and when he retired, he asked me to go speak. So I went in, these kids were in 3rd or 4th grade, and I was just talking about what a judge does, and I brought my robe and asked them why they thought the robe was black, to be a neutral. I didn't say neutral because they were only in 4th grade. But one after the other raised their hand in 4th grade, third or 4th grade. My father's in jail for robbery. Yeah, my uncle's in jail because he molested my cousin. They all started raising their hands to talk about who was in jail, and I didn't know what to say to them, and I was a little taken aback. So these kids at that age are already knowing about the justice system, and they know how it affects them. So we can't start talking too early or introducing them to judges and talking about laws and what laws mean and why we obey laws. I think it starts much earlier than law school.
Elise, did you have a follow-up question or a question?
If an attorney has a client that has repeat threats, maybe sanctions for the attorney or mandatory counseling following losing a case for clients, is there anything that you think would help in like a real practical situation?
In a real practical sense. So if it's the lawyer, if it's the lawyer who's making the comments or repeatedly behaving badly, then I think there are some real professional ethics issues there that will likely be reported. If it's the client who's doing it repeatedly, then I think that there are a number of different kinds of sanctions, and if the court issues an order, if the trial court issues an order and a client declines to follow it, then there are different sanctions that a court could consider, including civil contempt or criminal contempt, and that could range from fines to mandatory ethics training, or if you're a lawyer doing this, CLEs. I mean, there have been instances of judges issuing orders saying, you two lawyers can't get along, you have to go out to lunch together and split the tab and force yourselves to talk to each other. I don't know that doing that with a client is going to be effective, but there are different approaches. I have not ever heard of a judge ordering any sort of counseling, but you could order someone to attend some sort of ethics session or lecture like this. I mean, and then if they disobey that, then I don't know what the answer. It's another order that they've been non-compliant with. So there are some practical things that you could consider putting in place if you're having that sort of repeat issue with the same party.
And if there are threatening rhetoric, emails to your chambers or phone calls, they leave a lot of phone calls too.
Always after hours though. They're not dumb.
Right. Law enforcement, the marshals in connection with the U.S. Attorney's Office always looks at these to see whether or not they think that any of this rhetoric amounts to a crime. So they are, law enforcement is looking, unfortunately, not much of it amounts to a crime.
Well, I mean, we should all not, I think we've been, most of it's not a credible threat or amounting to a crime, and we're very lucky in that regard, for that reason. But your question about the attorney aspect of it leads me to sort of our and it's 4:46, and I do want to leave time for other questions if you guys have them. But we talk about what professional responsibility is, and the rules of professional conduct say that legal institutions in a constitutional democracy depend on popular participation and support to maintain their authority. So one of the things you can do when when people how to help spread sort of this word or to talk about it, people love to complain. And I think the next time you hear someone say, "Ugh, judges suck, the court sucks, everything stinks, like I don't like anything," it's up to you. This is a country built on population or participation by the population, by you and me. And part of demonstrating that respect for the legal system is the lawyer's duty to try to improve the law. And this goes to what I think law students should be thinking about. They're your duty to improve the law, to increase access to the legal system, to further the administration of justice, and to really expand the public's understanding of and confidence in our justice system and our rule of law. And that's incumbent upon all of us as well. So I want to talk just in our last couple minutes a little bit about the difference that we've seen in attorneys and pro se litigants, but really in attorneys' perception of the role of judiciary or its independence over the last years. And Judge Schwab, you've been a judge on our court for almost 14 years now. What have you seen change in terms of civility, professionalism, use of AI, expectations, any of that? And how is that threatening or affecting this idea of the rule of law and access to justice?
I think lawyers on the whole are professional to one another. I think people are courteous. There's outliers here and there. The biggest thing that I'm seeing right now, we've talked a lot here tonight about pro se parties. The biggest impact that I'm seeing is generative AI. That we are getting increasingly more complaints filed by pro se litigants using generative AI. These are really good documents. They look good. I don't know if they say anything worthy, but they're looking good. They're responding. They're formatted correctly. We have orders, some of us, that we send out that you have to disclose that you're using generative AI and what you're using it for. And I really think, the courts just stopped using WordPerfect last year, right? So we are way...
That's a little bit of hyperbole,
I know.
But not much.
I miss WordPerfect. But the
I think
courts...
they stopped during my clerkship, actually, which was about 10 years ago.
But
the
courts are just, I don't know if we're ready for this. I don't know what it is. We can't check every brief that's coming in to see if there's hallucinations in the brief and so I don't know, Sarah, what you guys do, like if you've experienced this, but I think there's going to be an explosion, and I don't know how it's going to affect younger lawyers. I don't know. Are people going to start taking it into their own hands? How it's going to affect the rule of law? I really just raise the issue maybe for another day. I know we're talking about the AI Law and Innovation Center here at Widener, but that's the kind of thinking we need to go. But AI, I think, is going to be the biggest impact to the rule of law.
But are you seeing that as well in practice?
I am. Not so, I would say maybe not as much in practice just yet. I've had some clients who have said to me, well, why are you billing me 5 hours for an associate to research this? I put it in ChatGPT and got an answer in 30 seconds, which is very frustrating and sometimes difficult to defend because sometimes it does a pretty good, sometimes it does a decent job, not necessarily chat, but, And I was telling the judges in preparation for this that I was at the ABA conference on white collar crime in San Diego. I think it was last week or 2 weeks ago. And I went to a session on generative AI and how to use it preparing for trial. And I was shocked that in a room of about 100 attorneys, when the panelists asked, raise your hand if you use generative AI every day in your practice, I was the only one that did not raise my hand. Which made me feel very behind the times, by the way. But I think the Harrisburg legal community, maybe it's not as, and some of these folks are practicing in the Southern District of New York and whatnot, and so they're really like on top of the technology. Now, it's certainly coming about, and it is scary. I mean, I don't really know where it's going, but I will say that I think most lawyers are skeptical, but dedicated to making sure that it's handled ethically and appropriately, and that people are following, the guidance of not, double checking your citation, which begs the question of, is it really efficient if you have to go back and check everything, which is currently what the guidance is. So
Right. So let me wrap up and then take some questions, but let me ask each of you a question. And Sarah, I'll start with you. There's a sense, I think, from some of us that these issues, these threats to the rule of law, these threats to the independent judiciary are really issues that come up in cases involving government agencies or, particular federal questions. But is that the case? And why should we be concerned about this in any case?
I think it concerns everyone. I think it concerns all parties, all types of litigants. I mean, as I said before, and as we've talked about tonight, it's the core foundation of our democracy, our courts, and our ability to get resolutions to our disputes justly and in an unbiased manner. So I don't see it being limited to matters involving the government or political, or rather federal question issues.
And Judge Schwab, and I didn't purposefully did not answer the second part of Kiera's question before, because what do you think we as members of the court can be doing in the face of these issues, these threats to the rule of law or the independent judiciary? What should we be doing?
I think we should be putting our heads down and continuing to work as we have always worked, and to make our opinions as clear as we can, to show our work, the whole math concept of show your work, so that our thoughts are out there and they're known. And I know, kudos to Judge Wilson here in the Harrisburg vicinage. She has started a courts in the community along with Judge Mehalchick, where we've just finished up a lecture series down at Dickinson College. Amazing. We had over 100 people attend, and we went through every 2 weeks different topics. Constitutional law. Professor Gemino spoke at the one that I did.
Professor Family was at our immigration one.
Yeah. our immigration one. So judges can't be on the road. They don't have a road show.
Except me, I'm on the road all the time.
I don't know how you do it, but
I work in my car.
Yeah, I mean, we have to keep out there. We welcome children into our courthouse. But there's only so much you could do because you have a job to do too. And I also think managing dockets is very important too. Not letting anything languish, moving cases along. I just do our job. Just do our job.
Right. And let us do our job.
Yeah, that's important.
Are there any questions in the chat or no? Okay.
Respond to, essentially making the point from this person's perspective that it's hard to reconcile discussions about preserving the rule of law with the agreements that some of the larger law firms made last year with the new administration.
So that's an interesting comment. The idea that how do you reconcile the idea of preserving the rule of law with the agreements that the law firms made vis-a-vis the administration last year. And I think that what I would point out is that I think when we're talking about the rule of law, we're talking about the role of the courts in it. I think legal groups and law firms and attorneys have another interest at stake there. They have an interest in protecting their clients' interests, and protecting their business, and doing so in a manner that still upholds the law and follows the law and complies with their constitutional oaths and as lawyers. But I think that what's important is what happens when that controversy comes before the court. And those agreements have nothing to do with what a judge is going to rule and how they're going to look at a case. So I think for me, that's how I would reconcile the preserving the rule of law from the judicial perspective of it. Other questions or comments? Yes, sir.
On what's the role of law, and I think to me, what's critical is that somebody say, words have meaning, and you can't say that any word means anything, okay? That we don't live in an Alice in Wonderland world. And the other is a response to the law clerk's question about what can be done, which is, I think there needs to be collective action, action by bar associations, maybe councils of judges, and say, when one president says, well, the word is doesn't mean is, and another president disparages judges routinely, that the bar associations, if no one else says that's wrong, period, it's wrong. Something like that.
And to follow up on that, I think that there are when there are attacks on judges or things, I think that lawyers, anyone can write to their newspaper, right, and write a letter to the editor and say, hey, I think what happened was wrong. Judges are a little more constrained with what they can do, although we've received guidance that we can speak out as active judges within the codes of conduct against attacks on judges. That's something that we are allowed to do.
Didn't a group of retired judges just get together? John Jones.
The group of retired Article 3 judges have formed the Article 3 coalition, and they are very active. They obviously have, as Paul Grimm said, he was a district court judge in Maryland, and he said, when I retired from the bench, I got my First Amendment rights back. They have a lot more room to say what they want to say. But yeah, I think it's incumbent upon, I would agree with you, it's incumbent upon everyone to speak up to the extent they can when they see something that it's what we teach our kids, right? See something, say something, with no regard for who's saying it. But I think that that's something anyone could do. Addie?
I think kind of a theme that I'm hearing here is maybe struggling with the idea of lawyers. Honestly, we're in all three branches of government, as well as non-governmental, which in that case you're still interacting with one of three branches of government quite frequently through the courts. And so I think it has to look different depending on what type of lawyer you are and how you engage. And so I think that is just a theme that I'm kind of hearing and being struggled with is if you're in a different context, are those people in each of those contexts behaving in the way that we might if we were in that context, or we would imagine we would. And I just appreciate that you're trying to put that context back into it, that there's different ways that, that Sarah and that Judge Schwab are going to be able to interact with this issue.
And I think for anyone, there are all different ways you can. So if you're comfortable talking to second graders, you should be doing that, because that's as important as talking to anybody else. So you find your room, and you find your space, and you do what you're comfortable with to sort of talk about what the rule of law means to all of us. Because the rule of law crumbles, our democracy crumbles, then what the Constitution stands for, and we the people, means very little, if anything. You're welcome.
Because it's been brought up multiple times about democracy and the importance that our system is perceived as being just and legitimate. Do you think that with the federalization of a lot of legal issues and the codification of certain rights as substantive due process rights, that across a very diverse country of 50 states, each with very different opinions and values, do you think that kind of almost making a one-size-fits-all solution to certain issues kind of causes some of the feeling that our system is illegitimate, and do you think that returning certain legal issues might help to quell some of those feelings?
So that sounds like next year's Jurist in Residence lecture. But I will say this, and not because I'm sort of chickening out or shying away from your question, but I think you're touching on an issue that is likely going to be before the courts in terms of nationalization of some laws and taking that power away from the states, because that is something that is percolating right now, which I expect is why you've brought it up. And so as sitting judges, I'm not going to touch that right now. But I think it's definitely an aspect. All I'll say is it's an aspect of what the laws mean and how our country functions. But that's all I'll say about that, and I'm not going to ask anyone to comment on that otherwise. Yeah, and I know we have to. What? Perfect. Okay. Okay. No, go ahead.
Friday we were in here discussing the
Dissent.
ability to dissent 25 or 250 years in this country. I get a theme out of here that we still should celebrate dissent, but there should be some guide rails. Respectful dissent, process dissent, emails throughout the night. But that's a tough issue of everybody has a different view of dissent. And as you elaborated on, when our government officials start to celebrate dissent in a more elevated manner or with rhetoric, I feel that also affects the judiciary, especially when they downplay the judiciary's work.
And I appreciate your comment, and I'll say this. I think that dissent, and I said this on Friday, I think dissent is essential to our democracy. It's essential to our ability to have this conversation and have these conversations. If there are 100 of us in this room, you're going to get 100 different viewpoints, and that's great. But the idea is that we do it civilly, we do it constructively. When you talk to your family, you don't say, well, I think you're a moron for thinking that way, and you don't talk to your colleagues like that either. And we disagree with respect, and I think that's what's key here. And disagreeing is by no means a threat to anything. It's the manner in which we do it. Thank you. Sorry.